Sorry for troubling.
No.
Matter not today. Tomorrow, if it is possible, AB.
You have filed?
Yes.
Yes,
Today we are just only.
It's an online filing.
Online filing.
You have the filing number?
Yeah, just okay. I remember earlier, later when we used to mention morning 10:30, 2 o'clock matter or less, and one of the judges is no more. He used to say, "You keep running. We will not list. You keep running."
That's true.
Then you also remember those days.
That was different, totally different.
No, today you are loaded with so many cases in the list we have.
Instead of having benches.
Even then, we find it, or really in my age, I find it embarrassing to move before this court, but no way out. So sometimes
It's okay.
we have to stop it.
Right.
Yeah. I am deeply opposed.
May I please, Lordship? This is motion matter earlier on 11/3/2025, and the motion is still a short time for filing additional. Additional file not listed. Please. So any date, my lord? Revision petition. 26th of this month.
Just a minute. That's what it. On 28th Friday,
20.
Wednesday.
Okay. Highly applauded.
Please, your Lordship. Lordship, I beg to mention a regular bail application. It was supposed to be listed this week, Lordship. Lordship, can it be listed for tomorrow, Lordship? Regular bail application, Lordship. Lordship, another item, Lordship, item number 36, Lordship, CD case diary is not available, Lordship.
Which police station?
All women police station, Panbazar, Lordship. Second subsequent date, Lordship.
Mr. Sharma. Second June. When he was arrested? Okay, second June.
Lordship.
2nd June.
Second June. Can it be the next week, Lordship, if possible, Lordship?
That will be on, otherwise the case there will not count. That's the reason.
Okay, Lordship, second June. Obliged, Lordship.
May it please, Lordship. My lord, I beg to mention item number 25, my lord. Motion matter, apparently matter may be possible for the day, it may be fixed on Monday matter. Monday. Obliged. Deeply.
May it please, your Lordship. My lord, this anticipatory bail was, my lord, fixed, my lord, on 27/5 for CD, my lord. Meanwhile, a day before yesterday, the father of the petition number 2 died, my lord. Today is the Tiloni, my lord. If, my lord, I have filed one IA today, my lord. If it's possible, my lord, to take the matter at 2 PM or, my lord, tomorrow.
You try at 2.
May I plead your Lordship? Lordship, I beg to mention for listing a BA minor. Suppose this matter is supposed to be listed for this week, my lord, but not listed matter. Monday, my lord.
Okay.
I'm obliged, ma'am.
Yes.
Yes, please, Your Lordship. My lord, I beg to mention item number 419, my lord. Motion matter, kindly pass over for the day, my lord.
19.
19. Most obliged.
May it please, Lord.
Yes, Mr.
I'm praying for upgrading two matters, Lordship, item number 42 and 43. The accused person received notice from the police to appear.
Item number?
42 and 43 in the supplementary list, Lordship. The accused person received notice from the police to appear at 10 this morning. So matter is some urgent matter will be taken up, upgraded, Lordship.
Bail matter shall be taken up immediately before the criminal. To take up criminal petitioner আগতে BA আৰু AB কেটা মাতে.
I beg to mention item number 17, my lord. This matter was laid by Mr. Learned Senior Counsel, Mr. K. Surrey, my lord. We were out of station yesterday. Therefore, he could not go through the file, my lord. This matter will be taken on next week, any date, my lord.
Item number 17,
Yes, my lord.
29.
All right.
Lordship, I beg to mention listing of one BA. There's some urgency on Monday,
When
Lordship.
did you file?
Yes, yesterday, Lordship.
Do you have the filing number with you?
Yes, Lordship. AB 4732 oblique 25
Good.
oblique.
May I please your lordship, I beg to mention item number 37, pass over the further day, lordship.
Is available.
Lordship, my senior is out of station, lordship.
37. Wait for some time. Yes.
May I please, Lord? So I beg to mention item number 32, my lord. We have filed additional affidavit regarding bringing some documents, my lord. So this matter may be come up next week, any date, my lord, along with the affidavit.
No, it's available. Okay.
May I
Yes.
please, your lordship, I am praying for listing one lordship, bail application on the Tuesday, lordship.
When did you file?
Yesterday, lordship. Tuesday, lordship, I am seeking, lordship.
Okay.
Deeply obliged.
May I please, Lordship, I beg to mention item number 24. With instruction from client, I may be allowed to withdraw the petition.
Just a minute. Wait for some time. Any other mention? No. Okay, just a minute. Wait for some time. Yes, ma'am. Yes.
Yes, pleasure, Lordship. I may be allowed to withdraw the case for tomorrow. BA 1108
Give it.
oblique
Give it.
2020.
Give the list.
May I please, Lord? I beg to mention for listing of a matter, Lord, I have filed the case yesterday and connected matter is fixed tomorrow in court number 18 as item number 24. So can this matter be taken up together, Lord? Item,
What is the PA number?
BA number, Lordship, 1497.
Make it
I
before
can,
the-
okay, and another two matters, Lordship. One matter was fixed on 9th and that is not listed till today. And in one case that date is not there and both matter relates to court number 15, Lordship. That bench is sitting tomorrow. Some matters are there in court number 15. So may I pray both of those matter may be listed tomorrow, Lordship? Court number, obliged, Lordship.
What's your good name?
JS Ahmed.
Pending the petitioner. नाम कितना है? What your page? PH किस नाम पर सबसे corresponding to clear now. 512. On instruction. खाली आके काट कर दो, ठीक है? और बीच में. Then dismiss them.
God bless.
The last occasion of the period not appeared. 9/5/22.
Sorry, yes, there is, will take up this matter. Will not help you.
Your Lordship, I have instruction to withdraw this instant bail application, Your Lordship.
But Mr. Real, come outside waiting for the petition. And we'll check it out. Very important. And then go put it photo, it's special. On instruction of the petition. Mr. Well, and also. Presented. Obligation.
May I please, your lordship? Lordship, 483 bail application, lordship, regular bail. Lordship, as of today, 60 days behind the bar, lordship. The allegations under section 103 and 140, lordship.
Fifth lot, fifth, sixth, 560. Murder lot.
Third,
Lordship, there is a violation of section 48 notice, lordship.
let the records come, that is what we require indicated. On third, Mr.
Lordship.
Obliged. May I please, lord? Lordship, there is a charge-sheeted case, lordship. Only before the district and session of Gwalpara, lord. FIR is page number 12, lordship. Parties for series in 2025, lordship. Party. 81 days, lordship, behind the bar, lordship. 81 days. Lordship, in a
What is the
arrest
case number?
lordship,
For the learned session judge. Charge sheet has been filed for Philip. Any idea what is the case number? No.
Case number two.
lordship, 62 2025, lordship. Session case number 62, lordship.
Sorry,
62 2025, lordship.
eligible spend of the records of. This is case number 62 of which we will provide. Arising out of one case number 12 of which we will provide. Corresponding to the year number 173 of which we will. In the PRC, we will do the calculation. Fifth of June. As on 38th of May. Registers the petition. He pending the pretty court of law. Additional simple.
Deeply obliged. Very good, lordship. Lordship, he has arrested on 1-3, lordship. So, lordship, from the date of, and forwarded on 2-3, lordship. From the date of fraud, lordship, as an 82 days will be there, lordship. 82 days, lordship. As on today, lordship, from the date of fraud, lordship. Lordship,
Mr. Das.
Lordship.
On 2nd June.
lordship, 82 days, lordship. Lordship, there is FIR, lordship, where it says only, lordship, some slave blow on, lordship, speak, lordship. This is the lordship allegation, lordship. So, 302, earlier 302, lordship, may not be attracted here, lordship.
Get it on 30,
Lordship.
I may pray for timing, your lordship, my senior is on leg, you know.
What's the matter about what you need it?
Lordship, the matter is about section 69 and 89 of BNS, your lordship. Lordship, the allegation in the FIR is of, on the pretext of marriage, both were adults, both were working together.
and on the pretext of marriage, relationship was established here. Whereas your lordship, there are several citations, your lordship.
This is from Lotus Hill only.
Lordship,
Lordship, a short date may be given.
29, Lordship.
Can it be on 26, your lordship?
28, no.
Deeply obliged, your lordship.
May I please, your lordship. Lordship, the alleged offense is a regular bill. The alleged offense is that the accused left a Facebook comment for another user that read Pakistan Zindabad along with 6 knots of Pakistan flag, lordship. Lordship, FIR is in page number 13.
Lordship, with a heavy heart, I am standing for the prosecution side today, Lordship. So I just indicate 2 things, Lordship.
But anyway, Mr. will be.
There was just indicate 2 things, Lordship. Because he does not deserve any fundamental rights granted under Constitution of India.
Lordship,
Just I point out 2 things, Lordship.
I was arrested and sent to judicial custody. I was not given a
This is
chance.
the first time in the history of the Indian judiciary, Lordship. This thing was happened, Lordship. This is the first time. Not only our High Court, Lordship, several High Court has done this, Lordship.
Lordship, I was not given a chance to clarify my action, Lordship.
Yes, what
I'm
happened?
a,
They wiped the sindoor of our Lordship sisters, Lordship.
You have sent us a circular.
Lordship.
Yes.
The circular is, Lordship, on that particular incident, that was for the first time in first time in the history of Indian judiciary, that was happened, Lordship. And he is celebrating, Lordship. That particular person is celebrating, Lordship. Where, Lordship, one of my sister, Lordship, after 6 days of marriage, Lordship.
That's all.
Lordship,
From Karingam,
Lordship, Lordship.
that will come from Sri Bhumi. It has the ticket for.
Let us see.
Today is 22nd,
Lordship.
10th of June.
Lordship, Lordship, Lordship. Oblige, Lordship.
much obliged.
Made this video. Empty.
From Botadra.
Yes.
Mr.
Lordship on court.
I thought that maybe we will not. Because of the fact that only one section is non-variable logic, all other sections are available.
Let it be on 4th only. So in case they won't get it.
Oblige.
I was arrested on my lord 16/5, my lord. FIR is at page number 8. Allegation is, my lord, regarding theft of a solar panel, my lord.
Sixth.
Lord.
Please, your lord. 483 application, my lord. FIR is page 14, my lord. My lord, from the report of the 48, my lord, annexed herewith, though, my lord, it has not been followed the provision of 48, there are no signature, but it has been mentioned that it is a case of committed suicide. Accused has committed suicide, my lord, in full. My lord, the allegation is that some money has been misappropriated by the accused person, for which he committed suicide. And 48, there is no signature, but it was never communicated to us. 47 has been complied, my signature has been obtained.
Okay, get in on 10th. Open.
May it please the lordship. Lordship, this is a regular bail application in connection with Gosaigao PS case number 57 of 2025, your lordship.
From Gosaigaon.
Lordship, there is another matter pertaining to same FIR, your lordship, which is fixed on 29 May, your lordship. Yes, your lordship.
Number.
Lordship, case number is BA number 1547, 2025, your lordship.
Of the same affair.
Yes, your lordship.
BA number
1547.
29.
Highly obliged.
May I please, Your Lordship? Lordship, absolutely, Lordship, of case, Lordship, lodged by the girl, Lordship. Both are adult, Lordship, and married, Lordship. Just few days relationship and Lordship, she lost this affair. Affair with phase 7, Lordship. She got introduced with him in the hospital. Thereafter, he developed some intimacy, Lordship, and subsequently she lost this affair, saying that he was used to stalk her and attempted to rape her, Lordship. This is the allegation. It's from dispute, Lordship. Can it be on 29, Lordship?
In many cases, again. Maybe on 6th.
Also, can it be on 3rd or 4th, Lordship? 3rd or 4th?
All are full, that's the reason, otherwise you'd have obscured.
So on 6th, there's some problem.
6th, you have problem.
Yes, Lordship. On 4th, Lordship.
5th.
5th.
May it please your lordship. Your lordship, this is a regular bail application and it is arising out of Gosaigaon PS case. Another one of the tag matters has been listed on 29/5.
Do you have the case number?
Yes, your lordship. 1547 of 2025. May it listed be on 29?
Yes.
Much obliged, your lordship.
My pleasure, Lordship. That's it for activity application, Lordship. Application under section 305 of BNS, Lordship. Lordship, I need purchase some articles, Lordship, from one arrested person, Lordship. The Lordship will find the FIR at page, Lordship 10. Captain dwelling house, Lordship.
Mr. Das, this is from Dhamaji.
Lordship, I had one more. 6. Dear Lordship. Lordship, the mother of the petitioner died on 19th, 1905. Ajay.
You will have to have the case there, that's all.
16.
Or get a report at the earliest if you want from the OC, the IO.
Look.
In that case. Get it confirmed, that is from mother as expert, and if he's not prepared, get
I
the
agree,
report.
interim prayer, Lordship. For release of the temporary release of the petitioner.
Do one thing, Mr. Das, today is 22nd. Give us an interim report from the IO on 29. Okay, get the report.
Lordship, I apologize on particular.
For the further custody detention, because we have to release him temporarily.
Lordship, thank you.
That's the reason.
Obliged, Lordship.
May it please your lordship. Your lordship, this is a regular bail application under section 483.
This is for forest.
Yes, sir.
Your lordship, if your lordship please come to the FIR, page number 12. The offense is registered under section 61(2), 325(35) of BNS, red with 51(1)(a).
Ma'am, get the report.
Offense report may be called for your lordship.
Give us a date.
A short date, your lordship.
Any date in next week, your lordship.
Second. Second. Majorly.
Obliged to.
Commercial quantity lordship, basically the tar sheeted metal lordship. They basically the ground of arrest and that we have filed a additional affidavit. Arrest no 40.
Eligible can copy of the NDPS case to be second. Will be good. Raising also feel like PS case in 29 rupees. First one, the GR number 135. As on 3005 will be right. Report of London Special Judge NDPS. Judge. RBM wrong depot. List on 9. 6.
Much obliged, your lord.
Now, this is an application for clear as bail. My lord will find the fire at case bail. The allegation being that been running an illegal slaughterhouse, madam. That is the allegation without license. We will turn to case bail that is a fire. In essence, my lord, that is what the fire alleges. But my lord, I am a valid purchaser, bona fide purchaser, and all the receipts have been sent to, have been routed through the market council.
Take your seat, Mr. Srinivasan. Mr. Client, but counsel appearing for petition. And the take it. Petition. Yes, case diary, lordship on 6th. Sixth, from Sutia.
Sutia, ma'am.
Third, Lord,
And I'm praying for interim.
we have seen that, we will consider on the next.
Congratulations.
May please your lordship. It is a pre-address bail application, your lordship. Page 8 is the FIR, the translated copy. Actually, what happened, my lord, some friends were having a party, my lord, then some scuffle took place. Allegation is that, my lord, the petitioner hit the informant with a wooden stick, my lord. They were having a party, my lord.
Just from Falcusi, lordship. On third. We have it on second, lordship.
Along with the injury report, your lord.
Along with the medical report of the informant.
I'm deeply obliged, your lord.
Your lordship, page 13, your lordship, is the FIR. Your lordship, there is a quarrel between the parties, your lordships. FIR and contra FIR was filed, your lordships. And ultimately, your lordships, both parties are hurt. I have also given the photographs of petitioner, your lordships, how he suffered.
Yes,
Your lordship, the second FIR filed by me is at page 80. And it is already charge sheeted, your lordships. The same thing, same information and same, your lordships, quarrels. Therefore, your lordships, page 25, I have also given the photographs of my injuries, your lordship. On what? 24, 23, 24, 25, your lordship.
yes, KD case, four lot. KD case from
In the
Ramapura.
meantime, your lordships, I am a serviceman, your lordship, at least I may be protected, your lordship. Let the city be called for.
On second. With procurator, it's a matter of FIR of March.
Lord. Much obliged.
May it please your lordship. Well, this is an anticipated bail application, my lord. FIR, my lord, is at page number 19. Basically, the allegation is that, my lord, there was some sort of theft in the Hubli-Fulbari flyover, my lord. And the victim, my lord, he named 6 persons as an accused. But these persons, my lord, the petitioners, my lord, are not named in the FIR.
Rather, my lord, they are the brothers of the accused number one Yunus, my lord. If your lordship will kindly see the last page, page number 24.
Yes, could you case the lordship on third? When? Lordship third. Page six. When? Dhubri, Lord. Give us a day. On 3/6, Lord. From Lordship, Lordship, from Dhubri, Lordship. From 22nd, you can get it by fourth, Lordship. Mr. Sharma, who is looking after your, these meetings to get your case diaries and all, somebody officer is there? Then why are all these things are delayed in getting case diary? Okay, on fourth. Mr. Das.
Hello.
My lord, in this case, co-accused has been granted bail, my lord. And my lord, in a FIR, my lord, my name has also been written wrongly, my lord. There is a doubt whether that person is concerned about me or someone else, my lord. And my lord, the true fact of the case, FIR is at page number 11, my lord. My lord, another thing, my lord, I am a political leader of that area, my lord. And regarding 10 lakhs, my lord, I don't have anything. I'm not concerned about that, my lord, because I have a bright future in my own profession, my lord. My lord, may kindly turn to page number 4, my lord. Here I have given my submission, which has to be note to this honorable court, my lord. Even I don't know anything about this case, my lord. My lord, may kindly turn to page number 4, my lord. My lord,
Just a
yes, ma'am.
My lord, in this case, my lord,
Please take case to come back to you.
yes, ma'am. My lord, in this case, actually, my lord, the informant and accused number 3, they both deals with business, my lord. And accused number 3 is all supplied the wholesale rate of carpets to this informant, my lord. And informant is supposed to pay 32 lakhs for this 40 bundles of carpets, my lord. But he has not returned that. Accused number 3 was constantly saying about returning of his 32 lakhs of that 40 bundles of carpets. He is not returning. And my lord, regarding this instant case, I don't have any idea, my lord. I'm a political leader and I don't have any idea regarding this, my lord. As the co-accused has been granted bail, my lord may kindly protect me, my lord. One reference case is here, my lord. I'm forwarding, my lord.
Who is the co-accused for bail?
Co-accused is, my lord, Yasin Mia. Yasin Mia. He has been granted bail, my lord.
Where is that order?
Order, my lord, Annexure 4 is whereby it has been stated that one Ranjit Das has been stand as local surety for the Yasin Mia. Annexure 4, page number 22, my lord.
Where is the order? This is with regard to bail bond.
Yes, my lord. This
Where
is
is the order of the court?
order, my lord. I have not able to take, my lord,
Payment
because,
of efforts order. Where is that order?
my lord, that order I have not able to take, my lord, because I am not connected and I don't know anything about this case, my lord. That's why, my lord. Only one person told me that Yasin Maya has been granted bail and that's why he has given me that, my lord.
See. See. See.
On 11/4, my lord, on 11/4, he has been granted bail. By the judicial magistrate, first class, my lord, Shri Guru.
Let's get the case there. Author can do. On 6 lot. 6th lot. Okay, on 6th.
My lord, interim protection may be granted.
That application was in after arrest. Bail was granted, he was arrested, he
ma'am.
was in custody for more than.
Yes, my lord, obliged, my lord.
Wait, please, Lordship. The petitioner here is a bank manager, Lordship. FIR is at phase 11. The vernacular is at 17. Accused number 2 is the petitioner here. Lordship. Is the name accused?
Who are you?
I am the bank manager, Lordship.
The bank
Arrange
account was open at this document at page number 21.
No, Lordship. This document was later, that paragraph 2 of the FIR, he said that I did not authorize the bank manager to send my email ID and account number. But this is the application by which he made the prayer for sends of his phone number. And Lordship may see at the foot of the application, page 22. An employee certified that the person personally visited and he made the application for sends of the. Here's Kolkata, at the foot name of the employer, here's Kolkata, he certified. I certified that this request letter is complete in all respect and the relevant documents are obtained and verified. The request may please be processed. The CRF has been personally submitted by the customer and the customer has signed the form and all associated documents in my presence. I have satisfied myself and the identity of the customer is verifying. By verifying,
It is
please
a
have
change
given-
telephone number, change mobile number.
This is for mobile number 600005451 for sense of this number. The second one is for sense of email ID. The same Lordship. Secondly, Lordship, if some amount is transacted in the bank account, the bank manager may not know what happens, who make the transaction. For that, he may not be integral in this matter.
Mr. Judge, get the case there when
Lordship 146.
along with the documents of the bank that you might have seen.
May kindly consider entering because Lordship 93 page 27. The petitioner is a patient of high blood sugar. It is 671 after fasting. So Lordship, some protection may be given. And he shall appear and he shall give his statement. Whatever his condition is given, he will follow Lordship. Lordship,
Get the case there by fifth. You appear. Today is 22nd, on or before 27th. 50,000 to local surety, one of government.
Obliged, Lordship.
in this case, the brother of the informant, elder brother of the informant committed suicide. And 108 section has been in the case. Particular version of the FIR is at page 17.
Das same bank, got to tell me, and lots of transaction into different accounts. Getting is there in the previous, it's not on sixth. There is something. Branch manager cannot keep quiet like that. Get the case diary by second. In both the cases. You appear before a Monday.
Roger.
Monday to take. Yes, ma'am.
May it please the lordship, an application under section 528 of BNSS, along with article 226 of Constitution of India was filed for quashing of alleged FIR dated 13/11/2024. Rising out of Gorjuk PS case number 363/24 dated 14/11/2024 under section 302 of BNS. Your lordship, it was an offense of theft. And your lordship, I was arrested only upon the statement of co-accused. The material that was stolen having value of
Yes, you have the
rupees.
case diary? There's a direction already. This is the case diary is sought for from Gorchuk police station. There's an order on 14th of May.
Yeah, I need to again verify.
Mr. Sharma, that is the reason we are asking you, who is looking after all this?
We have communicated with you. In 3 occasions, we have communicated with you.
Good. This is from Gorchuk on this. Yes, Gorchuk, Gorchuk is well aware. Any hotel in the park. Have it on Wednesday. This week. Spelling which you know. Yes.
Highly obliged, your lordship.
May I plead your lordship? Lordship, Jima was filed for a very full lordship. Lordship, the petitioner is not connected in this matter, lordship. Petitioner belongs to a very poor family. And the lordship, the petitioner is the registered owner of this vehicle. Lordship, the driver and the helper.
Mr. Das, the report was sought for. What happened?
Report for.
We have not. By order in 2nd of April, the report was sought for.
20.
From Rota police station.
But we have communicated it, Lordship, on
That will not be sufficient. You must ensure that it should be in the court. Your communication is not sufficient, Mr. Das. That cannot be a plea. That you have communicated. Are you helpless?
Lordship, we will have.
If you are helpless, let us know. We'll pass order.
Monday or Tuesday, Lordship.
The order was passed on 2nd of April.
Lordship. Last opportunity, Lordship, Monday or Tuesday, we'll get it.
We'll make it on 2nd of June,
Lordship.
and we'll see on that day.
Plead your lordship.
No representation and repetition. Let's stop the each other. You can go to the nothing.
May I please, lordship? Lordship, in this case, NBW has been issued to the petitioner, lordship. Interim order is in page number 13.
That may be called for, Lordship.
If despite taking police bail, accused did not appear.
Become. Done. Wait. Listed along with criminal petition number 103/2023. Criminal petition number 251. 2023. You have filed other cases. There are cases pending.
Yes, Lordship,
There are 4 cases which you have not stated anything about it. You have prepared a criminal petition earlier. You have also prepared a criminal revision petition. These are all silent in your petition.
criminal petition 1043, Lordship, 2023.
Where you have mentioned. What about the criminal revision petition that you have mentioned?
We have not filed.
My lord, may I submit maths? What happened, my lord, the other side, one Sandan Pathak has filed a 1043/2023. My lord. That is not related to this case, my lord, that is in a different case, my lord. Where I filed an FIR, and the charge sheet was filed. But in that case, my lord, they filed a criminal petition and
You have also filed a criminal petition.
Yes, my lord.
51.
another, for quashing of that, my lord, quashing of the present proceeding, probably there is, quashing of the present proceeding, there is another criminal petition filed by the petitioner. my lord.
You have not mentioned in your petition. But
That part probably not mentioned, my lord, it is not intentional. Only reason is that, my lord, because that was probably, my lord, my mistake that I thought, my lord, it may not be necessary because that is again quashing of the FIR, my lord. That is for the quashing of the entire proceeding, my lord. Now, in the present case, my lord, only my limited prayer was that, my lord, I may be allowed to appear. And the other, my lord, aspect, whatever decision by the honorable court, that will be different, my lord.
criminal petition is against quashing of that proceeding, my lord. That is probably in that case notice is issued.
List on Monday along with the criminal petition number 2512025. We'll have it on Monday.
Yeah, please, Your Lordship. Yeah, this is a application under section 528 of the NSS, Lordship. Here is a search-sheeted case, Lordship. Now the case is registered as PRC case, Lordship, and pending before the additional CJM Morigaon, Lordship. Here present 2 accused person is there, Lordship, and searches are submitted against Lordship 7 accused person, Lordship. Out of the 7, Lordship, 5 already appeared, Lordship. Lordship, may kindly come to page 20, Lordship, the search sheet, Lordship. The relevant part, Lordship. Accordingly, search sheet has submitted second paragraph, Lordship. Accordingly, search sheet has submitted against the accused person, namely so and so, Lordship. Residents of so and so under section 380-34 IPC and read section 13(1) of Assam Cattle Preservation Amendment Act, Lordship, for trial the case and prayed before the honorable court to issue non-bailable warrant of arrest against the other connected accused person, namely Shahjahan Ali, Aizul Haq, Ismail Hussain, Saidul Islam, and Abdul Salam, Lordship. Out of 5, Lordship, here present 2 accused person is preferring this present application, Lordship, and other 3 accused person already appeared, Lordship, as per the order dated, Lordship. Page 41, Lordship, order dated 22 of the learned court below, Lordship. May kindly come to page 41, Lordship. They are preferred an application in the session court, Lordship, and session court protect them, and according to the said order, Lordship, they appear, and they are appearing at this present stage, Lordship. So my humble submission is that, Lordship, they are willing to appear, Lordship. Some protection may be given, and I will appear and face the trial, Lordship. And Lordship, they neither receive any notice, Lordship, during the time of investigation by the police, Lordship, and nor receive any summon or Lordship available warrant issued by this learned court below, Lordship. So they came to know about the said fact, Lordship, from the co-accused, and they willing to appear, Lordship. This is my humble submission, Lordship. Some protection next date is 2026, Lordship, in this month, Lordship. So that may be fixed, Lordship, and I will appear, Lordship.
Pardon, Mr. A. Burwa, counsel appearing for the petitioners. And Mr. K.K. Das, additional public prosecutor appearing. Speaking of family something. File this application under section 520. PNSS. 120.05. Premium amount service. To enlarge them on bail by recalling the order of non-bailable warrant of arrest issued against them. in connection with the PRC case number 112/2023. Corresponding to Miami Police Station case number 103/2021. Presently pending before the Court of Planet Excellence of Judicial Magistrate. Morning. The petitioners are solicited accused in Murigaon PH case number such and such. So my own police station case, Murigaon, my own police station case number 103/2023. Corresponding to GR number 1925/021. The section 380. Or 54, I think. They read section 13 in bracket 1 of the Assam People Preservation in Internet. Thank you. Good night. Allow me. No. Yeah, that's. Eight hours. Along with 6 hours. Submitted. 30/12/20. By judge. The learner edition is a judicial minister. After submission of site charge on such and such, site my own PH case number corresponding to their numbers. Same has been registered as PRC case number. PRC number. Page 112/202. And remember it's pending before the Court of Planet Excellence of Judicial Magistrate. Right. Afford the taking cognizance of the offenses under section such and such. The learned magistrate issued summons to the accused petitioners. But in spite of the receipt of summons as the accused petitioners did not appear before the learned magistrate at Morigaon. Order of non-bailable warrant of arrest has been issued. Again. It is submitted by the petitioners that they are willing to appear before the Court of London Additional Chief Judicial Magistrate Morigaon. It is said, see number such and such. And that the next day of the said PRC number such and such. It's 26 years of right. It is also submitted on behalf of the petition that as the order of unbit agreement Issued against for the petitioner certain courts. Order to complete upon there of the apprehension that if they appear before the court of blood elections, if petition Morigaon on such and such, then say PRC number. They may be apprehended and detained in first. After hearing the learned counsel for the petition. And directed to appear before the court of additional judicial magistrate Morigaon in PRC number such and such on 26/05/20 and to file appropriate application for recalling the order of NPWA suit against them. And also for in the event of filing appearing before the court of law and such and such on 26/05/20 and in the event of filing any such appropriate application by the petitioners individually or with jointly and oblique or jointly for recalling the orders of NPWA issued against them in said PRC numbers. And also for the learned magistrate shall consider such applications of the petitioners in accordance with law. While considering the bail application, the petition is equal. The learned petition of judicial magistrate. Each one in PRC number. What's any such necessary order as a team fit securing the presence of the petitioner's name above in the said PRC number such and such as the law from my own. On the date fixed and during the trial till conclusion of the said trials. To facilitate the petitioner to appear before the court of law, judicial and chief judicial magistrate on 26/05. It's correct. That 26/05. The orders of NPWA issued against the petition. Say PRC. However, if the petitioner failed to appear before the court of law, let us insert petition on 26/05/2005 and get up inside PRC. The learned additional petition magistrate shall be liberty to pass any such order as it be fitted for the appearance of petitions. It is made clear that this order, the interim protection granted to the petitioners noted above is only up to 26/05 and it shall not be extended beyond the said period. Considering fact that this order has been passed in presence of the counsel for the petition. Therefore,
Pass of lights.
May I please? May I please, your lordship, I am appearing for item number 16, lordship. In item number 16, lordship, lordship already passed an order, lordship. List, may I pay, lordship, may I fix the date, lordship? I was there, lordship.
Nobody appeared.
Lordship, I'm extremely sorry for interference, lordship. So may take it, may take as a last item or lordship, may fix any date, lordship. Third, deeply obliged. And my presence may be recorded, Lord.
Don't, I will show you.
Deeply obliged.
Lordship, on the last date, report of the IO was called for.
Lordship, in this case, Lordship, first during investigation, this has been rejected, Lordship. Then, Lordship, they took a revision, Lordship. They firstly accepted, Lordship. Then in revision, it was rejected, Lordship. Now the charge sheet has been submitted, Lordship. In this case. So, Lordship may call for the scan copy either, or they may approach before the learned trial court, Lordship.
Mr. Das,
Lordship.
the matter relates to the seized reckoner.
Lordship.
We wanted the report
Lordship.
from the concerned member,
Lordship.
because those are seized matters.
Lordship.
So whether it can be, the Jimma of those seized reckoners can be given to the parent. Or what is the status, whether it has been already transferred to file? Right, the
Okay.
reckoners cannot keep it for long,
Lordship.
right?
Lordship.
So automatically it will be taken as a note or others. So that is why we wanted to know the report from the concerned. Calling for the records is different. It's
Okay.
first you have to develop the report. But it is state, because it's still in the go down that where you have kept it, after seizing the material.
Okay.
That's what we wanted to know.
Lordship.
To my understanding, Lordship, this order, Lordship, order dated, Lordship, 31/25, passed in the revision case text which they have prepared, the other side has prepared. The earlier Jimma order was set aside, Lordship. They were granted,
Lordship, if I may bring your lordship's attention to page 7, paragraph 6. Here it has been clearly mentioned that during the pendency of the criminal revision, the final report was already submitted, but that was not apprised to the court. And ignoring that part, the judgment has been delivered, setting aside the Zimma order, previous Zimma order, which was allowed.
now, Lordship, if the earlier order has been set aside, Lordship. Lordship will find order dated 16/8/24 at page 32.
Yes, Mr. Sharma, you are submitted some.
Yes, first Lordship, order, page number 32, Lordship. Here, Lordship, the Jimma prayer was allowed.
That's right.
Yes, thereafter, Lordship, they preferred one revision, that is at page 35. By this order, Lordship, the earlier Jimma granting order was set aside. Holding that,
Lordship, to make a correction, the criminal revision was not preferred by us. It was preferred by the investigation officer
Yeah.
of the case.
now, Lordship, if the order has been set aside, holding that it is at this stage of investigation,
Now, Lordship, the information that we have received, this is the case has been charge sheeted.
Petitioner is saying final report. Charge sheeted is not there. So if it is final report,
Lordship,
where is the case? That is the reason
yes,
that clarification has to be given by the IO only
Lordship,
and nobody else.
also we'll get that report.
Whether FR has been filed,
We'll get it.
so when, whether it has been accepted by the London magistrate.
Lordship.
क्या हो सकता है एक बहुत पहले FR number 14.
Whether that has been accepted by the London magistrate or not, that FR.
Yes,
And in that case, that is the why we have called for the report
yes.
from the concerned IO. When it was seized,
Lordship, it was seized on 15th
2023,
15/07 2024.
the FR is of page 23, not of 4. Kindly come to page number 19. Case itself is of 2023. I don't know what is there. 15/7/24, but at page number 19, it is 15/7/2023.
The FR is of 15 July 2024, page 19.
Mr. Sharma,
Lordship,
this is from Bongaigaon.
Lordship will get that report. Only thing, Lordship, the communication which we have received this, Lordship, it states that charge sheet has been submitted. On-
Petitioner is saying
Yes,
at para 6 in FR.
yes. The charge sheet is dated 30 April 25.
See, final report is final report. That's what
Yes,
it's normally it is either charge sheet or the closure report.
yes,
It is not the final report is also can become a charge
yes,
sheet.
yes.
But the we are using is not using the word closure report.
Maybe, Lordship. Okay, Lordship, we'll
Get
get
the
the,
information.
we'll get the report, Lordship.
The charge sheet has been filed when it has been filed. And
At
the
least the,
status of those,
yes, at least the status of the American article.
give us a date. We can give sufficient time on earlier date. That's the
Yes,
reason. But anyway,
Third or fourth, Lordship?
up to you, we have to give the report.
Fourth, Lordship.
Pleasure.
Yeah, Lordship, the CD has been called for, Lordship, but we have not received the same, Lordship.
Since 4th of April,
Lordship.
Lordship, multiple occasions this errors, Lordship. Still now, CD has not received.
it was on 4th on April and then second was on 30th of April.
Lordship.
Goreshwar.
Goreshwar, Lordship.
Monday, second filling which
Lordship.
IO has to be here.
Public.
May I please, your Lordship? Lordship, in this case, Lordship, we have filed an additional affidavit, Lordship, that the ground of arrest were not communicated at the time of arrest, Lordship. And we have annexed those notice, Lordship, in the additional affidavit. Please.
Take your seat. May I make one submission regarding ground floor arrest? May I make one submission regarding ground floor arrest? Regarding ground floor arrest, they have given the notice, the case records also the notice are available, 47 and 48. Here, Lordship, the coordinate bench of our High Court has taken a different view in relation to 47 and 48. If Lordship permits, I would like to place the judgment there. Need the number? Yes, Lordship. BA. No, in two different cases we have rejected. Yes. I think one is when. Yes, NCB Lordship, we have that order. Yeah, but it depends. See, if you go to the Vian Kumar or the David protest, yes. They have differentiated two things. Because in the forwarding, the ground of arrest will be there. Yes. And the notice, simply the case number. Yes. And 2-3 lines. Whether that can be constituted to be compliance of section 50, 58 or 57. No. But in some of the cases, there are different. Yeah. That they will give that for these are the sections. They have committed such and such. Also have been arrested. That is non-believable. So for your bill, you may approve. Yes, yes. So where those conditions are there, yes, informing the reasons of the arrest of the accused person, that will most of the, it has been compliance of section 47 or not of the here. But just mere 2 lines, reference case number such and such and such and such, and without indicating whether it can be considered, because in the Vihan Kumar and or in the Copy Workers state, they have not given the details.
Lot.
But it should be sufficient for the accused petitioner to understand.
Yes, lot, yes.
Right? That's what it has to be. Because during this period, I have also seen there are, it is difficult when there are materials in POCSO cases or in NDPS cases.
Yes.
Where it has been found in possession, the conscious possession of the huge amount of heroin or methamphetamine for the content. Any NDPS.
Yes.
Or considering the fact that in POCSO cases, their child below 14 years, they're not saying over 16, 17, but thing is this, he had an incident of 3 years.
Yes.
The girl, the victim is just 3 years or 4 years or 5 years. We have seen the accused petitioners as stepfather because of threatening the victim girl.
Yes, I remember.
So many things we have found in certain circumstances, but we have to consider that petition of vulnerability, particularly Article 22 of the Constitution. But wherever, to certain extent, it has been brought to the notice of the accused.
Yes.
To that extent, it will be compliant.
Yes.
But if just mere 3 lines, you are arrested in the above case, you will be sent for, you can apply for your bail.
Yes.
That will not have that.
Yes.
Within 47, check copy PNS or PNSS or here. What is the judgment you have said?
And also that is DA number 2656, public 24. This is order dated 1/5/2025.
I think the judgment will come soon, verifying it.
But just to Lordship clarify regarding the observation of the coordinate bench, Lordship. Lordship, all those citations were placed. Lordship will kindly come to para 14. This is of course an NDPS matter, Lordship, but Lordship, the observation regarding the grounds of arrest that I wanted to place before Lordship. Para 14, Lordship kindly takes up. Let's, in the quest to understand as to whether there is any guideline or notification for the police of how to fill up the column relating to grounds of arrest, it is seen that the learned counsel for the petitioner has not been able to refer to any such statutory prescription, either by way of any act, rules, or notification issued by the Government of India, State of Assam, National Human Rights Commission, or by other statutory authority. Now, Lordship, this goes to the facts of the case, Lordship, where the contraventions were found in their possession, Lordship, from their house premises, Lordship. Thereafter, Lordship, paragraph 16, the coordinate bench has distinguished the cases, Lordship. Lordship kindly takes up 16 paragraph. In the case of Vihan Kumar Supra, the learned counsel for the petitioners referred to paragraph 14 and 21F thereof and has submitted that owing to non-compliance of the requirement of informing the arrested person of the grounds of arrest, the arrest stands vitiated. However, it is seen that in para 12 thereof, the Supreme Court of India has referred to the Constitution Bench decision in the case of Hari Kishan versus State of Maharashtra, so and so, of the requirement to communicate the grounds of arrest. In para 13 of the cited case, the Supreme Court of India has also referred to the case of Lalu Bhai Jogi Bhai Patel versus Union of India, wherein it is observed that the detainee must be communicated grounds of arrest. In the cited case of Vihan Kumar, the grounds of arrest was not communicated to the appellant, which is not similar to the facts of the present petitioner. Case of Prabir Purkasta Lordship, there is a specific observation by the Supreme Court of India in para 7.6 thereof that the grounds of arrest were not informed to the petitioner either orally or in writing. Moreover, in paragraph 47 also, it has been mentioned to the effect that on perusal of the arrest memo, the same nowhere conveys the grounds of arrest. thus the facts in the present case is not similar to that in the cited case of so-and-so. It goes on, Lordship, all the cases have been discussed. I will not burden your Lordship. Your Lordship kindly comes to para 18 for a moment, Lordship. In the present case, the petitioner have not taken the plea that no grounds of arrest was ever communicated to the petitioner. This plea has been taken up in paragraph 4 of the additional affidavit filed on so-and-so by a brother of the petitioner. The said statement is found contradictory to the contents of annexure A and B to the said affidavit, which contains photocopy of the arrest memo dated 8/5/22 in respect of both the petitioners, where against the column for grounds of arrest, the following remark has been made: sufficient evidence found against me. Here, Lordship, I will have to go to the arrest memo if it is there.
It has been already typed out.
Yes.
It's there in the paragraph.
Yes. Therefore, the plea taken on behalf of the petitioner by an additional affidavit filed by one so-and-so appears to be a false plea, as the statement that no grounds of arrest was communicated to the petitioner delete by the contents of annexure A and B to the said affidavit. Accordingly, from contents of annexure A and B to the said affidavit filed on behalf of the petitioner on 28/4/25, the petitioner have admitted that they were served with an arrest memo which contains grounds of arrest. In other words, the petitioner do not dispute the memo of arrest was not served on them. As mentioned in paragraph 7 of this order, in both the arrest memo, the grounds of arrest is disclosed as sufficient evidence found against him. In the said context, the submission of the learned counsel for the petitioner cannot be accepted on the ground that ground of arrest was not served and not communicated to the petitioner in writing. The court is not called upon to decide as to whether the remarks in the two arrest memo dated 8/5/22 to the effect that sufficient evidence found against him was sufficient or not, or how much disclosure should be made in an arrest memo in connection with grounds of arrest when the drugs were seized from the compound of the petitioner, stored in the cowshed, coinciding with the arrest of the petitioner in the same compound. None of the cases cited by the learned counsel for the petitioner lays down any specific parameter of what should be the contents of the grounds of arrest. None of these cases are authority to the point that the remarks in the grounds of arrest stating that sufficient evidence found against him is grossly insufficient information to the petitioner which vitiates the arrest.
Actually, I think this arrest memo is different than section 58.
Yes. NDP. Yes.
We are related to section 47 and 48.
Yes.
Currently, we are otherwise. And here are also judgment that if the court during the deliberation of the matter or in a property, see that there was a violation of any provision convert the right.
Yes. Absolutely.
Question of it is
there is no doubt for that.
that you file it with additional expected or bring it at. But we have seen that. Here, the learned coordinate bench of some different that in the arrest memo it is sufficient.
Yes. Even your Lordship, if Lordship also takes up the 47 and 48 in the instant case, here Lordship the case number as well as the sections of law are mentioned. Yes. And in the 48 also Lordship, it has been duly informed to the.
Yes, duly
relative.
informed.
Also,
48 has been complied with.
yes.
Only to see the section 47 notice.
And also Lordship the forwarding, because the forwarding is also under scanner Lordship. Forwarding Lordship will find at page 14. Lordship, can you take up the forwarding? Lordship will find
Forwarding
the
will
reasons
not
for.
be given to the accused petitioner. Forwarding will be only given to the learned magistrate at the time of production. So. They have complied with nicely.
Yes.
Now talking about 47, clarify whether this will be within the parameters written by the Honorable Apex Court in the beyond as well as the public question.
Well, in this type of cases, Lordship, POCSO, it cannot be said, Lordship, that they were not at all aware of.
No, they are fully aware.
Yeah, now, Lordship, whether that information that was given to them, whether that is sufficient or not, Lordship, that is the question. Now, Lordship, none of the Supreme Court judgment states, Lordship, what is sufficient or not, Lordship.
That the at least clarification indication is there at the public capture.
Yes.
That reasons of arrest.
On grounds of arrest depends.
If I'm not wrong, Lordship, in probably to Castro, Lordship, the grounds of arrest were not communicated either in writing or in orally, Lordship. But here, Lordship, at least
In Beyond Kumar,
in
they have
Bihar,
been said. That's why the clarification has been sought for. It is not happening here, it is happening everywhere in the state, everywhere in the country. We had a discussion in the academy at
Yes.
Bhopal. The honorable judges from the Apex Court also realized
there has to be a distinction, Lordship. All these cases
that's why
cannot
they
come
have
to the
taken up the
same
issue.
end, Lordship.
They are fully aware in the when we went last when somewhere in March. We had discussed this issue. Normally we discuss all these.
And then, Lordship, also
the
the
academy.
grounds of arrest needs to be communicated, that is okay, Lordship. But the time frame, Lordship, he is forwarded the next day, he engages an advocate, Lordship. Whether it can be said that he doesn't know how he has been arrested or on what
This
grounds.
is at the time of 47, 48 is at the time of it. Before Purna.
But Lordship, in one of the judgment, it has been clarified that it has to be reasonably in a reasonable time frame, Lordship. The forwarding also comes within that reasonable frame.
See, in some cases, it is not possible. Say,
Yes.
one issue I can tell you. I visited a particular place deep inside the forest. The forest ranger told us that it is difficult. It is in a particular border to after catching the poachers to take them to the particular police station.
Okay.
It takes more than 24 hours because they have to walk. It takes more than 24 hours, and in that kind of thick jungle, it is not possible that you will be able to cross a large distance.
Yes.
Walking, they have to wait because they are in some states, even by 3 o'clock the sun, it's totally becomes dark, thick forest.
Lordship.
So they are difficult
Lordship.
to for production within 24 hours.
Yes, Lordship.
So those difficulties, but the law is that within 24 hours you have to produce.
Yes.
But it is very well clear that for the such, because we have consulted to this, thereafter we took up those matters in our academy.
Yes.
And the forest rangers have been well trained what procedures to be adopted. So these difficulties only when these are practical difficulties.
Yes.
Unless it is not an open forest where you can walk in and walk out.
Yes.
There are forests, even thick forests are there in Assam.
Yes.
Particularly bordering Nagaland or Arunachal Pradesh or even Bhutan.
If Lordship permits me regarding that forwarding, if Lordship kindly.
Yes, it is before us.
Yes, Lordship kindly take some one order that is in BA 1100 1100. BA 1100 oblique 25.
BA 11.
Yes, 1100.
Bail application or BL?
bail application, BA
1100.
1100 of 25,
100.
1100. Order dated, Lordship will find 9/5/25, date of order. Yes, if Lordship kindly comes to paragraph just to 23, Lordship, paragraph 23. Paragraph 22 for a moment, Lordship.
22.1 or
22, Lordship. Page 15.
Yes.
Yes. In the present case, it is apparent from the aforesaid remand order that the accused petitioner was informed of the grounds of his arrest upon being produced before the jurisdictional magistrate within the stipulated period of time. That apart, it is further apparent that the grounds of such arrest were also informed to his relatives. That apart, the jurisdictional magistrate, after hearing the accused petitioner and satisfying itself that the mandatory requirements of arrest has been complied with, ordered remand of the accused petitioner. The short question first is whether the grounds of arrest been made known to the accused petitioner by the judicial magistrate upon being produced within 24 hours of his arrest is sufficient compliance with Article 22(1) of the Constitution of India. Now paragraph 23. Undoubtedly, no fixed time is provided under clause 1 of Article 22 within which the information of the grounds of arrest is to be provided to the arrestee. However, what is provided thereunder is that when a person is arrested, he is required to be informed as soon as may be of the grounds of his arrest. Thus, the expression as soon as may be, as appearing in clause 1 of Article 22, assumes significance. In common parlance, the said expression as soon as may be would mean as early as possible or within a reasonable convenient period of time. No straitjacket formula can be adopted to calculate as to what would be a reasonable convenient period of time to constitute the expression as soon as may be, as appearing in clause 1 of Article 22. The mandatory safeguards under Article 22(1) must be protected, not jettisoned. However, what cannot be overlooked is that the protection that is provided by the Constitution to an arrestee is that he should not be kept in custody detention without being informed of the grounds of his arrest, and that he is mandatorily required to be produced before the nearest magistrate within 24 hours of his arrest. The object of informing the arrestee is to enable him to make his representation against the order. Therefore, the combined effect of clause 1 and clause 2 of Article 22 is undoubtedly that if an arrestee is informed about his arrest upon being produced before the jurisdictional magistrate within 24 hours of his arrest, the same would be sufficient compliance with Article 22. Here also, in the order, it has been held that the
You are the magistrate inquired.
Yeah.
You are the magistrate inquired and the accused was
here also
could defend him.
But
There are certain matters where the accused are produced before the magistrate. You will see different orders of the magistrate.
yes,
There you will see the magistrate will not ask. That is why in the Vihan Kumar that point has been discussed.
yes,
It is the duty of the magistrate to inquire.
satisfaction. Yes.
And then whether that is why you see cases for very from very, you will see that now the LADCs are there. Earlier there are no LADCs. That is when the panel advocates are there. So that is why the magistrate is to always ask whether you are going to defend by yourself or you have your lawyer. If you are not having, we will be providing you this lawyer from the panel. So to that extent, whether at that point of time in the orders, if you see of the learned magistrate before whom it is produced, then you will see the case that the magistrate will never inquire whether he is aware of the grounds on which he has been arrested. But if the magistrate also informed the grounds of arrest on which he has been arrested, it is sufficient compliance. Because that's how the Article 22 should not be filed. That means the arrestee could know why he has been arrested.
Yes.
It is his right to know.
Yes.
And then it will be again, there are two parts in 47 as well in 50. Then that is to defend himself, he can engage his own counsel. And if he doesn't have a lawyer of his own, then the magistrate will prefer any counsel. Earlier it was penal counsel, now it is LADC. Things are like that. But if he is not made known to the accused by the magistrate on his or her production. Things are different. If it is not there in the notice 47, but 47 has to go prior to production. Even that is, there is no time limit by which, but that compliance of Article 22 will be complete if the magistrate informed him. What are the grounds on which he has been arrested? That's the law. That is why in Vian Kumar they have explained that the magistrate also did not inquire in that particular. But if any case in any other proceeding, it is not simply that simply 47 notice is not complied. Okay, let us assume to that action. But if the magistrate immediately on the date of the production, that is why in the other case they have discussed the ground of arrest in the forwarding and in the notice, the reason of the arrest cannot be considered to be same. Right? So you have to read the judgment as a whole, not parawai.
Here also in the remand order also I have not gone through whether the compliance is there.
No, remand order. You are talking about the order passed by the learned magistrate on this production?
Yes.
Yes. That is why it will vary from case to case. It's just enough to just say that only one.
Yes.
Just seeing 47 notice or 50 notice, that is not the case. But if it has been, the magistrate have informed the accused.
Where in fact, Lordship, in this order, Lordship, on an unrelated issue, it has held that the Pankaj Bansal case is prospective, Lordship, not retrospective.
Necessarily prospective.
Yes.
Unless the judgment itself it is made that it is giving that perspective. All judgments are prospective.
Yes.
Have you checked his record after production?
I could not go to that because also it is not updated, Lordship. The present status is also not available, whether DNA report has been submitted or not. Like, no?
Yes, Mr. Sharma, that's for your own satisfaction. So it to Madam Chaudhary.
May I make my
Thank you, sir. Thank you. Turn the page, they'll know. Everything. That part, that is the role of the maths. That's the rule. Right? Difficulties are, in fact, earlier, before testing. The new magistrates, when they are trained, they've been asked in terms of the judgment, the apex court, what they have to verify. They have verified.
Yes.
Till that period, that judgment of the apex court continued. Thereafter it changed. Now all the magistrates have started inquiring and noting down.
Yes.
The accused has been asked whether he has been arrested. The accused said yes, no. Then these things are different. But they are at that point of time. Magistrates are fully aware, okay, we had read to this. Okay. But child was born to the victim.
Yes, Lordship. The DNA report was supposed to be collected.
Because it is seen that
My lord, item number 46, last item, my lord, review petition at two lordship will take.
will take up before.
Next review, Lordship. Here in this case, Lordship, I have filed one additional affidavit, and the Lordship may kindly peruse page 36 to 39, Lordship, that no grounds of arrest were communicated to the petitioner at the time of arrest. Start on page 37, arrest memo. On merit also noted that in cross-examination, the victim herself said that no physical relation took place between them. She is the
See, there are different cases in different way. They are writing the notice under section 47. Here, the sections have been provided to you. Case number has been provided to you. All also been informed that you have been arrested in such and such case. You have been informed that the police cannot grant you bail because it is a non-bailable of police case. And that is why you can have file petition before the court for your bail. What else is required?
So that is what I have placed for also that in Bihar.
That is why, see, basically, in the, don't compare it with the arrest memo. Or don't compare it with the forwarding report. Here you have been personally involved, personally informed. You are fully aware. See, only when Article 22 is clarified that if somebody is arrested without any warrant, he should be made aware under which provision he has been arrested, so that he can make necessary arrangements for his bail. Here he has been complied with,
For such arrest.
right?
No.
Reasons are there, which are the sections are already been there.
No, reasons of arrest and grounds of arrest are to do. That is what I am supposing
That
to.
is, we are talking at, you have been arrested under these grounds. Sections are there.
So these are in general nature, therefore it will be lordship that reason that against me one FIR is lodged, therefore they have arrested. That is the reason. But grounds, lordship, that will be different, which necessitated the arrest.
That is why kindly read, you are hereby informed
Lordship.
that you have been arrested in connection with the above noted reference case.
Lordship.
That reference consists of everything, the sections under which you have been arrested.
So that probably lordship is sections comes. If somebody asks me what is there in section 14 of POCSO Act,
That is not
probably I
the,
have to look
that
into the
is
book.
not
lordship.
the, that is not the thing. If you read section 47, what else is required? Very clear.
Full particulars of the offense, that is not there. Lordship. So
Why?
एक बार
Offense is there, sections are there.
sections are mentioned, but full particular that who laws by whom, against whom, those what are the natures of the offense, those.
That much is not required.
For your lordship, I fixed it tomorrow at 2. I will satisfy your lordship on that.
Good. Priority petition, June till Monday. Monday.
All right.
All 47 notices are not alike. That is the reason, case to case, that's why it is varied.
No.
Eighth is lordship. The principal allegation against the petitioner is under 64 of BNS, an attempt to commit an offense of 64 against his own niece. The informant is his own brother. Lordship, before placing the FIR, let me just point out one thing. I have been in custody as of today for 232 days, more than 7 months have elapsed. The charge sheet names 14 witnesses. Only 3 have been examined till date. Because however, the victim and the informant, both of them have been examined. But over 7 months, only 3 witnesses could be taken. So there is no hope of the trial progressing at a speedy rate.
Then the records are not updated, lordship, because only one PW evidence is there in the record, PW1.
Yes. Thereafter, 2 witnesses have been recorded, the informant and 1 more witness.
That is not in the second copy, lordship.
Just now, we were late because we had that meeting. You'll be surprised to know how many cases are pending before the POCSO Act. In Guwahati, almost 900 something, almost 900, 880 or something. How a POCSO judge will able to record evidence in such case? And in fact, These are the difficulties. Last week we had a meeting to sort for the advices. Now, clearly stated that public prosecutor, one special public prosecutor is not enough to manage a POCSO case. The reason is the victim or minor first is required to be acquainted with the court premises. First time a victim, minor victim appear in a court premise. Just imagine what will be her mind, right? She will be scared of many things. She will see police personnel, she will see many things. And it is the duty of the special public prosecutor to keep her away from the accused. Once the victim comes and see the accused, she will be threatened automatically. She'll be off. The fear psychos will be there. Why he is sitting there? So she has to be accustomed with the then her evidence. By that time, there will be another 2, 3 minor victims how they will be acquainted with. So there was proposal that along with the special public prosecutor, there is a requirement of additional public prosecutor who can ease the job, because that special public prosecutor has to argue, has to place the case laws, case the evidence and everything. And then also it is how it's happening. It's happening hardly. In some cases, one special public prosecutor is duly appointed, has to also go for other courts to attend. So these things are happening to know the reality. But I to visit the districts, I know what is happening. It's to always contact with the people. It's happening, it's difficult. Every judge is saying it is so difficult, why it is not happening. The reality is something different. Though it has to be completed in within a year, having these number of cases in Dhubri, 1,000 plus. How do we expect a judge to finish 1,000 cases in 1 year, particularly? And difficulty, you cannot have the evidence, the child, all these 1,000 cases, same thing.
That's why also in some of the cases we have seen that the PWs are not examined due to paucity of time.
Not paucity of time, it is cases there and the people have to come from far away. All these things are there. But the reality. In fact, I informed your director of prosecution from Tinsukia when I last visited. That's 2, 3 weeks back when I had at Kitana. I went cross over the river and went to Tinsukia. There also you see that for the Margarita, there was no public prosecutor. The public prosecutor was from Tinsukia, was taking only bail. For the last 6 years, there was no trial. Definitely the accused will get that benefit. These are hard realities. And now I've been told that the list have been prepared. Shortly, it will become,
Almost done.
I think it is the chief minister's approval or something like that. But even then it will be short again. Every POCSO judge, needs at least an extra hand. So we have been discussing what to be done.
Lordship will please also consider.
You able to read?
Yes, sir.
Then we have marked another page, PW wants evidence.
Yep. Almost same. Similar.
Read it once again, Mr.
Yep.
Read the 183 first and then go for.
Regarding the name of the relative.
No, not on that. The act in 183, it is different. You just read the RPW, the evidence with.
That is different, but somewhere I have also gone through, I have found that she tried to commit suicide.
Maybe because if in society have to play, that is a different issue.
Some variation may be there also, but that itself is not enough to disbelieve the statement.
No, we're not saying, but in 183, those are not there.
Yeah.
What happens there in an evidence?
Minor contradiction may really, but and considering the fact also that the accused is the one related person. I guess they had pointed out that 3 PWs have been examined.
No, we'll get. Third mystery aspect, counsel appearing for the petition. Mr. P. Sharma, additional public prosecutor. Also heard MS. K. Brown, granted amicus curiae for the informant for the respondent number 2 / informant of the case. Command. Father of the minor victim. Guessing that the record is only up 24th of March 2002. Call for the up-to-date records of sessions within bracket special case number 278/20 with effect from 23/04/2025. 230-05-202. Eligible cancel. Sessions rising out. Output is proof, yes, case number 104. List on. Ninth of June. Register the petition. Please.
May I please the clause? My lord, charge sheet case, my lord. My lord, the count of arrest, my lord, was not communicated.
Let us see.
Case, my lord, 27 is the notice under section 50, sir. And present status of the case is, my lord, for evidence.
Mr. Salma.
In this case, I think.
That's the difference.
Yes, sir.
All cases you cannot compare that.
Yes, sir. Only just forwarded, nothing else.
Nothing. That's why in the case of previous case,
Yes, yes,
Mr.
yeah.
Azad Hussein's case is different. Here is different.
And even 6324, it is 50 CR with me.
No, whatever. The thing is this, that itself notice, whatever is required. That information has to be clear. Here you have seen that a different. The previous notice under 47, the Azad's case was different. Here it is.
You can express bail. All
That is the reason we are saying that in every case you will not see the same thing. That is totally different.
But regarding the merit method, Sajid came in December, 11 December 24. And last order was of 21/1. Subsequent to that. for the-
Mr. Sharma, that yesterday we have asked you to see that WT. It is WT match. So what the information. They sense the WT because they, let us assume he's a driver from UP and the helper is from Haryana. In that case, nobody will be there. And that is why the provisions are there that you have to be, when arrested, somebody's presence, some local person is also required here. But it's not what they are saying, WT means, WT has been sent to the family. Anyway. Oh, WT. Pardon, Mr. S. Ahmed, counsel appearing for the petition. And Mr. K. Parasa, K. Parasa. Petitioners. This is your second bail application.
Yes, second.
090. Very important. Special NDPS case from NDPS 32/2024. Arising out of Bhadarachara police station. Cars under 6. 20, you can get small, you can get small. Okay, 25 of 25 of 29. Okay, right. Next. On 11/12, 20. The bail application of the petition was earlier rejected. By the scope. On 30/01/20. In bail application 370. The petition is submitted that considering the detention in custody since 0.5, they should be considered. Okay. In addition, the petition is also submitted that while arresting the on 06/03/2024, by the authorities of Bhadarachara police station inside Bhadarachara police station. The authorities concerned did not comply with the provision of section 50 of CRPC, 50 and 50A of as required. In that regard, the petitioners relied on peruse the records of the special judge, special DPF case number 7. Along with the records of other PS case 247 of that were called for by order dated 55. Matter relates to recovery of one 317 kgs of ganja from the conscious position of the petitioners. 05-2024. During Naka checking. From a 12-wheeler red color open body truck bearing registration number PB 65 AB 7496 by duly authorized police personnel from Bajaritara Police State. Police personnel from Suraibari Police Outpost. Police watchman. Driven by the petitioner number 1, where it was with the helper of the truck, petitioner number 2. The said certain such cases of ganja recovered from the secret chamber of the said. The ganja were kept hidden in 150 numbers of scrap rubber bags. The secret chamber. In 439 numbers of packets. The petitioners recording the apprehended along with the said passport number. On filing of the FIR, was initially registered as Library Watch Post AD entry number 705205. Now being forwarded to the further police station registered. Further police station case number 47 of the 224 and 20 Manipur. The petitioner were arrested on 06/06/20 and were put before the Chief Judicial Magistrate. Time on 06/03/2022. the records it is seen that the FSL report dated 12/04/2024 confirmed that these substance recovered from the contract possession the petitioner to be cannabis in the country. Search it in the case and say whether it appears case number 13. Or submitted. Zero 05032024. 17/08/2024. Not 5, 17/8/2024. By charge sheet number 112 against the petition under section 23. Thereafter, take a sense of special NDPS case number 32/2024. And as a pending petition for the special NDPS. From additional session. Sri Bhumi. Query. Start the petition. 11/12/2024. However, from the records of the case, it is said that though notice under section 50 CRPC have been served upon the petitioner at the time of their arrest by the concerned investigating officer of Other Police Station case number 47 on 06/03/20. Copy of it was also received by the copy of the receipt of which was acknowledged by the petition. But the same were not in conformity with the provisions as required under section 50 CRPC in the law laid down by the input nature. Thereby violated. The sins. Repeal of it says actually 2 lakhs.
Obligement.
You have the case diary, Mr. Parashar.
My lord, I have to just run, my lord. Can it be taken up after the next item, my lord? I'm out of breath. Briefly, my lord.
35 lordship series evaluation. Lordship, may kindly go to the statement of the victim.
You'll be referring some matter itself. We have the.
Yes, notices of look. That may be appointed because
Mr. Sharma, Lordship. Medical report is not proper, it is not in the format.
Medical report, it's not there, Lordship.
Let's simply forward it.
Not.
That medical report is not.
Can get the people also, but
That report is not.
even then there will be a little consequences also. Because incident occurs prior to some days.
Whatever, but that report is not reported.
Yes, that is.
Lordship, I short submission, Your Lordship, in respect of an exact page number 18, page number 13, Your Lordship. This is an FIR, Your Lordship, which was lost on 1st April, Your Lordship, by the victim's mother, Your Lordship. Evidently, she left the rented room on 31st March, Your Lordship. On the next day, on 1st April, the mother lodged an FIR on the victim, Your Lordship, that she has taken 1 lakh rupees 12,000, Your Lordship. It is at the rented house of the informant's family, Your Lordship, of the same campus, Your Lordship. Also, maternal and uncle, Your Lordship, the victim took rupees 1 lakh 12,000, Your Lordship, and on 31st March, Your Lordship, she eloped with his friend Sona Singh, Your Lordship.
If I think that we not pick up on the exam. The informant. Respondent number 2. Informant father of it. The informant fit. Mr. Karim,
Lordship, may I pray for
page number 2.
12?
2 of the petition. Look at it.
Page number
2.
2.
What do you have? Will not entertain your bail petition. Will dismiss it.
Yes, page number 2. Respondent number 2 is the informant, Your Lordship. Informant from victim, Your Lordship. And as per rule, I have to serve notice to her, Your Lordship.
Make the judgment of the appeal. You dismiss your petition.
But page number 10, Your Lordship, at bottom, Your Lordship, victim herself lost the FIR, although she is a minor, Your Lordship.
Our father's
Then
name is there.
to whom I have to serve the
Our
notice.
father's name is there.
I may be allowed to modify, Your Lordship.
Withdraw and
Simply.
file, not something. File appropriate application, then we'll come.
Withdraw, Your Lordship.
File appropriate application. For your fault, why the accused should suffer?
Lordship.
File appropriate application. Place this matter. After showing, declare of the consent. Take that case there.
Obliged.
Please, Your Lord. The murder case, my lord, sheet has been submitted. May I pray, my lord, that the scanned copy of the LCR and the case diary may be called for, my lord. Lordship may examine the matter on merit, my lord.
Mr. Sharma, when did Sakshi was
The fix was filed on 20 of this month.
You see, it's a case of 302.
No,
Sorry, no, this.
103, subsequently added.
But will not go to the court of Planning Sessions at this moment. It has to be committed to the.
Committed to the court of,
But it has to be.
so my magistrate will not be able to take up the bail. So
Not
this will
only
take.
only that, that is the reason.
Yes, ma'am.
Can approach thereafter, but by that time it will be better. Otherwise, thing is this, it will take much time. Because probably it just search it has been submitted, it has not yet been placed before the CGM.
One of our contentions is, my lord, regarding violation of
Whatever.
22. my lord.
It's, you can place it before the court of Planning Sessions judge of that Tulaga. Bring it to that aspect. Whatever we are doing here,
Yes, my lord.
that aspect you can do, and on the perusal of the reports, the Planning Sessions judge will look into it.
No. No, the issue is that there are multiple accused persons who are there. my lord.
You can understand.
So,
There are not only one single person, there are many, but this is, charge sheet has been filed. Otherwise, it will take time. Will not get it early.
we're
That
still
is the
willing
reason.
to take a chance, my lord, because on the, one of the reasons is, my lord, if there are multiple accused persons, appearance will take some time, committee will take time. So we are hoping if your lordship calls for the.
Call for the, that will be better because it will be done in the Golaghat itself.
Alright.
Gutta courts are here and there.
My lord.
You can understand.
Yes, yes, ma'am.
So that will be better for you. Otherwise, you can call it and it will take time. That's the reason. Up to you to decide.
Or we'll take a chance. Provided your lordship.
No. Otherwise, it would have been easier. Anyway, you want to take it. Charge sheet number.
Charge sheet number 91. 2005/2025.
Administrator has now counsel appearing for the petition. Mr. P. Sharma, additional. Petitioner was arrested.
27 to.
27. And actually, Kolakans police station case number 48 of 2005. Section. One with number 2 of the. PNS, that is section 103. Yeah. And then during the deliberation of the matter, Mr. Sharma and answer. Place of completion of the investigation submitted. The section corresponding to GR number 288 of it. Summary the charge sheet on 20/05/50. I charge sheet number 91. 91, right?
Yes.
202. Call for the legible scan copy of the record. GR case number, GR number arising out of Kolakans police case number from the court of Rani.
Chief Judicial Officer program.
Seek petition. To break. List on. 16th of June. Rest is mentioned. Clear, somebody's case was rejected.
Anticipatory bail was issued.
Was it AB?
AV, my lord. I'm deeply obliged, my lord.
May I please, Your Lord?
Yes.
Yeah, I'm the only one who is not charged with the, I'm the only one who is charged with the arms act here in this case. Actually, is here in this case, in this, the informant is the informant is the accused actually.
That case, Lordship, where the wife. Yeah, Lordship will find one thing, Lordship. The petitioner has been charged under 25(1)(a) and 35 of the Armed Act, Lordship. The weapon, Lordship, it was found from his house, Lordship. And therefore he was
Not from my possession.
from his house, Lordship. So he was charged under 25(1)(a) Arms Act. And Lordship, till date, 5 witnesses have been examined. They are all protected witness, Lordship. Because this petitioner also is an ex-NDFB
No,
militant. So
no, Your Lord, so this is untrue. I am a
in any case,
farmer by
Lordship, under the Assam Witness Protection Scheme, Lordship, some of the witnesses have been granted anonymity. So the trial is progressing, Lordship. At this stage, releasing him, Lordship, will be a very serious matter to the witnesses, Lordship. And it has been discussed by the order dated by the court itself, Lordship, by order dated 24/4/25 also, that aspect was dealt with by the trial court, Lordship.
The witnesses who were examined, Your Lordship, they have not mentioned, they decline actually. It is there in the deposition.
And earlier, Lordship, one of the co-accused bail application was also rejected by your
That is
Lordship.
because of murder charge is there in the charge. It is a case where a citizen should not be allowed to possess a weapon which is not allowed. It's just that, but involvement in that is not there, Your Lordship. I became a victim. Now languishing for the last more than 400 days. I have a small 2 kids and only
You
source
are?
of wealth.
Lokendra Basumutari, right?
Yes, Your Lord. Because the real culprit, the real offender, he is my neighbor. He was a banana tree. He kept it there. Very unfortunate I am. And he called me on the phone when maybe 161 during the police statement. They made him call and they came and they surrounded and they discovered, not me, not I did not hand over. They came and they got it themselves. That means they were already informed beforehand. If involved, then that charge should have been there. And innocent is in grave injustice. I'll face the trial, which is now evidence is going on already. I'll face, Your Lordship. How can I harm the protected witnesses? Allegation is I took 500 rupees for hiding a weapon, murder weapon. How can such a grave offense and I'll take only 500 rupees to corroborate such a big offense? I'll take more if I'm an offender.
Heard Mr. A. Nartari, learned counsel appearing for the petition, and Mr. P. Sharma. Petitioner and English suspense. File this application under section 483 PMS, praying for his way, on 29/11/2022. Praying for his way. In Sessions case number 73, right?
Yes, sir.
Within the PGM, Mobile 2024. Arising out of Long Police Station case number 2226. Public 2024. And section. Twenty-five within bracket 135. Of the answer. That's the picture. Since case 76. Okay, what 76? Mr. Sharma, in records, somewhere it is showing 73, somewhere it is 76. Should be 73, I think. 73 probably. 75. Okay. 78 probably. No, it should be 73. 70. In which the petitioner was arrested on 01/07/2024. And is in custody. Since then. Lordship in take Bongaigaon PS case number 226 of activity of the submitted on 2309-2024. And charge on protection of 825 of rent against the petition at such and such. On 21 10 2024. Considering the detention in custody since such and such, the petitioner has paid for. That's it. Mr. Nursery, some that there are about
78.
10.
778, page number.
78 named prosecution witness. The certificate. As on date. Evidence of how many prosecution?
Like 5, I think, protected witness. It will take years.
5 protective witness. Were applied were thoroughly cross-examined by the defense, including it is seen from the records of the case that Delana District Magistrate Bongaigaon on 2309-2024 granted necessary sanction as required under the Arms Act 1959 to proceed against the accused persons of the case, the said Bongaigaon PS case number such and such, including the petitioner. The case record reveals that the accused petitioner and another accused involved in the murder of the deceased resides together in the same locality, a nearby house. And the petitioner and the murder weapon was recovered from the house of the petitioner. That was hidden in it. There is also seen that case record indicates the accused petitioner had communication with the other accused persons of the case prior to the incident and also after committing the murder of the deceased. Petitioner is one of the named accused out of the 8 accused persons of the state, such and such. Peruse the records. That's purchase as well. So I get a typical The petition is submitted on behalf of the petitioner by making another 11th that according of evidence of all 78 witnesses, prosecution witnesses, will take long time as that only 5 protective witnesses have evidence of 5 protective witnesses. Considering the please take your seat. The petitioner is paid on behalf of the petitioner that considering his detention in such and such, the petitioner should be comfortable. Considering entire hearing and on perusal of the record, the court is review. Depends on the petition. Since the cannot be considered for failure. Say. Right. It detention cannot be said. Is right. But still particular. Usually it's capital. So, we'll put it up. That's it. Not- The application of petition.
May please notice the anticipatory bail application, the FIR page lordship, 12 lordship. The informant is the 50 years as a payment, and the petitioner is the 20 years lordship. Informant is the widow lordship, the honey trap lordship, the petitioner lordship. At the time of occurrence, the petitioner was minor lordship. Yes, 12 lordship, the barnacle. May I read lordship, the সম্মানপূর্বক বিনীত নিবেদন এই যে 2 বছরমান আগত শাহানুর আলী পদকীয়া জনে মোৰ ইচ্ছাৰ বিৰুদ্ধে বেকাম কৰে আৰু লগতে ভিডিও কৰি ৰাখি দিয়ে আৰু ভাবুকি দিয়ে যে উক্ত ঘটনা কাৰো আগত প্ৰকাশ কৰিলে ভিডিওটো ভাইৰেল কৰি দিয়ে সেয়েহে মই ঘটনাটো কাৰো
I am reading 2-3 lines, Malad. Statement of one co-accused, Malad, may see.
That will be only 61-2, my lord. Otherwise, I was not there on the spot, my lord, and nothing has been recovered from my position, my lord. The arms which has been found abandoned, my lord, in condition, my lord. I have in Annexer C, my lord, page 39. And it was found in the paddy field under someone's pond, my lord. That was not my house.
Yes, after the incident, Malad, উক্ত কাৰ্যৰ লগত আমি জড়িত আছিলো আৰু উক্ত কাৰ্যলৈকে বিলাসীপুৰা আগদিনা শাহজাহান আলীৰ ঘৰত মিলিত হৈছিলো। শাহজাহান আৰু আশিদুল ইছলামে আমাক জনাইছিল যে মেৰানগৰৰ SBI CSPত 20-30 লাখ টকাৰ লেনদেন হয় আৰু তাত ডকাইতি কৰিলে বহুত টকা পোৱা যাব। লগতে জনাইছিল যে ডকাইতি কৰি পোৱা 50% অফিচৰ শাহজাহানে ল'ব, বাকী 50% আমি ভগাই ল'ম। They are the main persons who suggested and all give the details. And investigation is still going on. And these 2 persons not yet arrested. Main persons are not yet arrested. And their custodial interrogation is very much necessary. It's an organized crime.
Lordship, I was not there during robbery, my lord. Nothing has been found from my position, my lord.
See, if the record says something else,
My lord.
we can be.
My lord, may-
favor. But if records are against you,
2 pink color flag,
And all the co-accused, they have granted bail, my lord. I have annexed in
after their arrest,
my lord.
not on pre-arrest.
Yes, my lord. That is true, my
So
lord.
when you are arrested, not yet
No,
arrested.
not
So
yet.
you better go and come out.
But within 33 days,
Then
they have
otherwise
granted
you
bail,
have
my
to go
lord.
and run.
pink color flag,
And nowhere my name has been reflected, my lord.
The investigation is going on, that's how it is coming out.
Neither from the co-accused also, my lord.
That's right.
The arm which was found abandoned in the paddy field, my lord, without ammunition.
Apprehending is a petition and a petition. Praying for his baby. Support from peers. Corresponding to the enemy. The petitioner earlier also approached this court for his weight in state support from case number 58. In the court after appraisal of the case, that by order the 25/02/2025. First in AP number 6/4 rejected the bail of the petition. Next. The contents of the petition is that in the meanwhile, other accused persons of the case have been released on bail. And further, the arms involved in the case was recovered from a different area within Beckett Pond, right?
Yes, ma'am. Near the paddy field.
Near a particular,
In a bamboo jungle.
without any ammunition on it. And that the petition is no way connected with the case. From the records of the case, it is seen that the persons were already arrested, accused persons of the state, were already arrested. When they released on perusal of the case, there it is being that there was sufficient incriminating materials against the petitioner to regard to within 5 days. The investigation of the support company is still going up. And some of the accused persons of the case, including the petition. Yet, consider could be apprehended. Considering the materials in the considering the incriminating materials available in the against the protected it's the pre-arrest to the petitioner.
Bless.
So I am put a respondent number 1, lordship. Respondent number 2, lordship. I need some time to file my objection. Lordship. Opening 811. My appearance to come.
You want to file objection?
Lordship.
File it within a week.
Lordship, here in this case, section 230 of BNS, it deals with Lordship evidence and living Lordship. In this case, I am the accused. And this question deals with as Lordship section 230 says here.
Let him file the objection. We'll hear it next week.
Can it be on 4th, lordship? June 4th.
Today is 22nd.
Second, lordship.
Lordship, on the last order, there is an order that interim pair shall be continued, shall be will be interim pair will be considered after receiving the case record. So please interim may be given to the petitioner until the objection.
Second, lordship may dispose of the matter.
Maybe until the finally interim may be there.
Since 10/12/2024 on various pretexts, you did not appear before the Court of Learned Magistrate.
Yes, Lordship.
Right? Or Mr. H. Burwa, counsel appearing for the petition. You have filed local letter?
Lordship. Probably that is not on record, Lordship.
Okay.
Keyboard like.
No, let us just put it.
Lordship.
When did you file?
Lordship, yesterday, Lordship. Respondent number 2, Lordship.
Somebody else's name has been put.
Lordship, whose name is on, Lordship?
DN Bora.
Lordship, two are there, Lordship, T.N. Bora and P. Board. In the column number, both are there.
And Mr. B. Sharma, additional public prosecutor. That's point number 1. Also heard Mr. P. Bordole, counsel appearing for the informant. That's point number 2. On reply of Mr. Bordole, counsel appearing for the respondent number 2. She is allowed to file her objection if any. Or no before. Thirty-eighth of May, serving a copy of the same on the counsel for the petitioner.
Lordship.
As well as the additional public prosecutor. Respond number. List on 3rd June.
Lordship. Oblige you, Lordship. Oblige.
Representative. Because the received, where is the office note dated 20/005/2025? Pertaining the receipt for the relevant records. That was our records of PRC case number 63120.
Oblige you, Lordship.
Yes, Mr. Sarkar, what is the matter about?
It's my lord. My lord, the case was, my lord, moved on 15/5 and it was fixed on, my lord, 27/5 for scan copy of the CD. But meanwhile, my lord, day before yesterday, on 20th, my lord, the father of the petitioner number 2, my lord, died, my lord. A certificate I have annexed, my lord, at page 7, my lord, of the Gau Pradhan Navaboisha Lakhimpur. Therefore, my lord, for some religious purpose, my lord, today's Tiloni, my lord. It's to ask out of the 6 sections, only 118 is there, my lord, previous heard. But my lord, even learned trial court while granting the bail, my lord, regular bail to other accused person, my lord, after going through the injury report, found that it's a simple, my lord, injury.
My lord, then only
Because this,
Only one.
this number two. But for this limited period matter.
Twenty-seven. Expired on
Expired on my lord 20 of this month, my lord, 25 to 25. Day before yesterday.
apprehending his arrest. The applicant as petitioner filed AB number 1067 of the 2025, praying for his plea as paid in Laluk PS case number 82 of 2025 under section 296 of 126 within bracket 2 of 118 within bracket 2 of 351 within bracket 3 of 3 within bracket 5 of the BNS. Corresponding to GR number 359 of 2002. That was moved on 15/05/2025. The court, by order dated 15/05/2025, call for the scanned copy of the case diary of said Laluk case number such and such, and fix the matter on 27/05/22. By filing this application, it is submitted that the father of the applicant slash petition in which is the petition number 2. Applicant is petition. Filing this application submitted that the father of the applicant, Arendranath Sharma, son of Prayodhar Sharma, resident of village number 1, Ioa Mura, post office, Bari, Okanoti, Northern Ambucha, police station, Laluk district, Lakhimpur. Expired on 20/05/2025. In his own residence. To that extent, the applicant has annexed a certificate dated 21/05/2025 issued by the Town President of number 1 Hatiomura village. Hence, the petitioner is praying for conditional PRS paid for a limited period, to which Mr. K.K. Parasal and additional public prosecutor has no objection. Considering the same, the petitioner 5th of June. More than 15 days. Till 5th. 40,000 to local. Appear before. Appear before I on or before 26th. In the case report, we'll place it. Place the connecting. The AP2 clip. Parts are simple. In the connected IAC 5302 petition number 2. Such and such granted interim date. Conditional interim date on the date of this father on 20 April 520. List of 06 056 2025 till that petition of petition number 2.
That's it.
Is there on that day? Yes, Mr. Sharma.
Yes, my small pair, my lord. To lordship has.
So was just point out. You
Yes.
have seen yesterday, I have read.
Yes, my lord. My lord, page.
What are the grounds?
My
you
lord,
say?
page 15, this is the order passed by your lordship, that on the basis of instructions submitted by the government advocate, that his case was placed on 3 occasions and case was rejected. But your lordship will appreciate that the first minute, page 17. Only recommended names are reflected. And last sentence, the deputy commissioner is requested all officers to submit their remaining proposal.
Just it.
Then second minute, page 19. There is also no reflection regarding rejection of my name. Last sentence, the proposal placed by various department were verified thoroughly and recommended. Only recommended names are there. And last sentence, page 21, the deputy commissioner is requested all clerk officer to submit their remaining proposal. In the second meeting also, my name was not reflected. Then third one, page 22.
Where is it?
On the page.
Next page, next is of 21st of July 2024.
Yes. First one is at annexer B, it's page 17. Then second one, page 19. And third one, page 22. 24/7/2015.
In the second one also, your name is not there.
Not there, only there are some annexer. Annexer 1 and 2, annexer 3. Also a recommended candidate 1 and 2, and list 3 is as per honorable court's order. And there is no reflection of my name. Thereafter, my lord, the government has filed an affidavit. Page 27.
Just it. Where is the affidavit?
Paragraph 3, middle part.
Affidavit filed on 8th of June.
Yes.
Paragraph 3.
It is seen that from the records available in the office of the Sonto, the district only the recommended list was recorded in the minutes, and list of rejected candidates were not recorded in the minutes at that period of time, except having honorable court cases. Statement of candidates to be placed in the DLC meeting were prepared at that period of time, and thereafter only the recommended list were recorded in the minutes, keeping aside the rejected candidates. And at that point of time, the reason as to why the rejected lists were not signed by the then authority is not known. Then paragraph 11. Before that, though my case was rejected, they have stated that page 30, you Lordship will appreciate, they have annexed some consideration list, particulars.
Page 31.
30. They have
Where?
annexed.
In your petition?
No, they are affidavit.
Page 30, huh? No, page 30 is not there, but it's page 31 is there.
29, then 30. 31
Earlier
also.
some mistake might have been.
And maybe my lord, 30.
Annexure 1 you are talking about?
Yes, my lord.
Yes, Annexure 1 we have said.
Then my lord, annexure
That
1.
is of 18/12/2023.
Yes, my lord. Yes, my lord. Then serial number 114, my name is reflected as a particulars. Then my lord, page 31, my name is there, Nizumoni. Criteria fulfilled.
No, you are, what is your good name?
My lord, Nizumoni.
No, 114 is some Ranju Pegu.
Then my lord, page 31.
You are not Ranju Pegu.
My lord, then next page. Next page, second name, Nizumoni, criteria fulfilled. On the next page again.
This is when?
2014.
25/7/2014.
Yes, then page 32, 24/7/2015, last name, criteria fulfilled. But they have prepared a rejected list. Next page, page 33. Then that list was prepared in the year 2021. Whereas my case was considered on 3 occasions in the year 13, 14, and 15. And rejected list was prepared in the year 2021.
No, it was 15, page 34. Reject list of DLC dated 24/7/2015.
But the preparation date, my lord. Last sentence, last signature, 4/9/2021. My name is reflected at serial number 18. Due to insufficient 5% reserve quota. And another name was also reflected at serial number 38.
Your name is at
18. Yes, ma'am. Due to insufficient 5%. Yes, ma'am. Then 38, serial number 38. Another candidate, my lord, her name also rejected. Then that person approaches honorable court. Here is a judgment passed by the honorable court stating that though that was rejected belatedly, and honorable court directed to as per OM dated 1/6/2015.
Where is that order? Do you have the copy of 2015 OM?
Yes.
Can you give us a copy?
Yes.
You have extra?
Yes.
You have?
Yes. Clause number 15.
And it was subsequently modified when?
That was not modified, but in the year 2024.
But prior to that date, 1st of April something?
Yes, that was earlier, Malan.
No.
9. That was the latest notification that has been followed by the state government. Thereafter, no such notification. In the year 2017, that notification has been.
No, in place of job, you'll be paid some amount.
Compassionate family pension. Compassionate family pension that was came into force from 1/4/2017. That was issued on 14/9/2017. But prior to those who
14/9/2017, that was giving effect from 1st of April.
Yes, there is a clause 10 that those whose father or mother died on or before 1/4/2017, the case will be covered as per 1 dated 1/6/2018.
That will be available in the
Yes,
website,
my
I
lord,
believe.
yes, that can,
That was 2014/9/2017, right?
yes,
That is by the finance department.
yes.
There's another matter, we'll write together.
Yes.
We'll allow the review, Mr. Deori. Ma'am, you are allowing, appearing for? Forgot your name. Now, no, not appearing in the, not taking up the education matter, so
Yes.
names are not mentioned. B. B for? Ah, say, how come you are in B Bombay?
Mumbai.
Upon Deori. Bitopon Deori. Again.
Since
Not in
my
that.
DLC is going to sit, my lord, so you.
We'll do it.
Yeah.
We'll be writing up to Saturday, no time.
Yes.
Saturday have meeting and the whole day. Sunday will sit.
As per clause 15, my lord, as per that.
Mr. Theory will allow it.
Yes.
Yes. There is another matter, remember that we have not do it. Okay. In the meantime, Mr. Sharma, if you know if that PLC is likely to fit, just let us.
As per correspondence with the officials, it is likely to. Yes,
When, any idea?
just recently, because,
Yeah.
after the direction of the honorable court.
There is serious matter was disposed of.
We have to, allow order to, place all the pending case.
Okay, okay, we'll wait.
They are likely to see.
By Monday, we'll get the order.
Okay.
Okay.